The Homeland Security Department has identified the man they say was the ringleader of a foiled terrorist plot to attack the UFC event at the White House over the weekend. According to DHS, the suspect is Abraham Alvarez, an immigrant from Mexico who was living in the U.S. illegally after overstaying his visitor visa. He and 4 others were arrested in connection with the alleged thwarted attack. The FBI says Alvarez organized the plot in an encrypted group chat, planning for the use of snipers and drones to target senior government officials. The Supreme Court Thursday ruled in favor of a Texas man who challenged a federal law that broadly banned drug users from owning guns. The unanimous decision is a loss for the Trump administration, which had defended the 1968 law. It was also used in a criminal case against Hunter Biden, who was convicted of buying a gun while using cocaine. The case created unlikely political allies. Both the ACLU and NRA supported the case against the law, while the Trump administration and gun safety groups defended it. CBS News legal contributor Jessica Levinson joins me now. So, Jessica, interesting case, strange bedfellows in this case. What exactly did the high court say?
So the court said that this federal law, which prohibits habitual users of drugs or drug addicts from owning guns, cannot be applied to Mr. Hamani. Essentially, that would be too broad an application, given what the court has said about the Second Amendment. The court looked at old laws, like laws that prohibited habitual drunkards at the founding of our country from owning guns. And the court said, those just don't match up. There's not a good historic analog. There's not good enough guidance to indicate that we could have prohibited, again, at the time of the Second Amendment, at the time it was ratified, that we could have prohibited somebody like Mr. Hamani from owning guns. And that's why I think you see this unanimous decision, which you don't typically see in a Second Amendment case. So it's just as applied to him. We don't have an answer as to when the statute could be applied and future applications of the Supreme Court's recent Second Amendment cases.
So given that, where is your mind in terms of what this could mean for another case? Do you think that they will try to bring this in as the new precedent?
Great question. What we're really doing in this case and in others is interpreting that landmark decision that the Supreme Court handed down, the Bruin case, a number of years ago. And so I think this case, a case called Rahimi from a few years ago, we're trying to figure out all the situations in which, under the new test, which basically says you can limit somebody's ability to buy and own a gun if that's based on the text and the history of gun usage, again, when the Second Amendment was ratified. All of these cases, I think, are trying to flesh out what that really means. Does that mean if you are accused of or convicted of domestic violence, you can't own a gun? If you are accused or convicted of other felonies, can you not own a gun? In this case, we're talking about somebody who used marijuana every other day, and there was no proof that he was a danger to himself or others. So all of these cases, I think, are trying to figure out, what does the new standard mean? When can we limit gun ownership? When can't we?
Okay, Jessica Levinson, thank you.